Fundamental Principles. 2019, a non-governmental organization operating in the Philippines which seeks to promote equality and human dignity in the workplace has 40 rank-and-file employees. Can the employees of this cause-oriented, non-governmental organization form a labor union? Explain briefly. The employees of the non-governmental organization may form labor union. Under Article 3, Section 8 of the 1987 Constitution, the right of the people, including those employed in the public and private sectors, to form unions, associations, or societies for purposes not contrary to law shall not be abridged. Here, the non-governmental organization's 40 rank-and-file employees have the right to form unions, associations, or societies. Hence, the employees may form labor unions. 2009 enumerate at least four policies enshrined in Section 3, Article 13 of the Constitution that are not covered by Article 3 of the Labor Code on Declaration of Basic Policy. 2%. 4 policies enshrined in Section 3, Article 13 of the 1987 Constitution which are not covered by Article 3 of the Labor Code on Declaration of Basic Policy are 1. All workers shall have the right to peaceful concerted activities including the right to strike in accordance with the law. 2. They shall be entitled to a living wage. 3. They shall participate in policy and decision-making processes affecting their rights and benefits as may be provided by law. And 4. The state shall promote the principle of shared responsibility between workers and employers. 2008 explained the extent of the workers' right to participate in policy and decision-making process as provided under Article 13, Section 3 of the Philippine Constitution. Does it include membership in the board of directors of a corporation? 3%. Under Article 13, Section 3 of the Constitution, the workers shall participate in policy and decision-making affecting their rights, duties, welfare and benefits, through labor management councils, see Article 211 G and 255 of the Labor Code. The workers' rights do not include membership in the board of directors of a corporation, see Meralco versus Meralco Employees, GR number 127598, January 27, 1999. 2007, what is the principle of codetermination? 5%. The principle of codetermination is one which grants to the workers the right to participate in policy and decision-making processes affecting their rights and benefits. Article 255, Labor Code. Alternative answer. By the principle of codetermination, the workers have a right to participate in the decision-making process of employers on matters affecting their rights and benefits, through collective bargaining agreements, grievance machineries, voluntary modes of settling disputes and conciliation proceedings mediated by government. Alternative answer. Codetermination is a term identified with workers' participation in the determination of business policy. Under the German model, the most common form of codetermination, employees of some firms are allocated control rights by law, in the form of board seats. It is based on the conviction that democratic legitimacy cannot be confined to government but must apply to all sectors of society. Besides corporate control rights, the German system deals with dual channels of representation of employees by unions at the industry-wide and microeconomic level and works councils at the firm level. 2009, in her State of the Nation address, the President stressed the need to provide an investor-friendly business environment so that the country can compete in the global economy that now suffers from a crisis bordering on recession. Responding to the call, Congress passed 2 innovative legislative measures, namely 1. A law abolishing the security of tenure clause in the Labor Code, and 2. A law allowing contractualization in all areas needed in the employer's business operations. However, to soften the impact of these new measures, the law requires that all employers shall obtain mandatory unemployment insurance coverage for all their employees. The constitutionality of the 2 laws is challenged in court. As judge, how will you rule? The first innovative measure, on abolition of the security of tenure clause in the Labor Code, is unconstitutional as it goes against the entitlement of workers to security of tenure under Section 3, Article 13 of the 1987 Constitution. The second innovation measure, on a law allowing contractualization in all areas needed in the employer's business operations, is legal. Article 106 of the Labor Code already allows the Secretary of Labor and Employment not to make appropriate distinction between labor only and job contracting. This means that the Secretary may decide, through implementing regulation, arrangement where the person supplying workers to an employer does not have substantial capital or investment in the form of tools, equipment, machineries, work premises, among others, and the workers recruited and placed by such person are performing activities which are directly related to the principal business of the employer. Hence, it would be legal for Congress to do away with the prohibition on labor-only contracting and allow contractualization in all areas needed in the employer's business operations. Assuming, of course, that contractual workers are guaranteed their security of tenure. 1998. What are the salient features of the protection to labor provision of the Constitution? The Constitution, in Article 13, Section 3, provides that the state shall afford protection to labor, local and overseas, organized and unorganized. The state shall afford protection to labor by promoting full employment and equality of employment opportunities for all. Workers are entitled to security of tenure, humane conditions of work and a living wage. The state shall guarantee the right of all workers to self-organization, collective bargaining and negotiations, and peaceful concerted activities, including the right to strike, in accordance with law. Workers shall also participate in policy and decision-making processes affecting their rights and benefits as may be provided by law. The state shall promote the principle of shared responsibility between workers and employers and the preferential use of voluntary modes in settling labor disputes, including conciliation, and shall enforce mutual compliance therewith to foster industrial peace. The state shall regulate the relations between workers and employers, recognizing the right of labor to its just share in the fruits of production and the right of enterprises to reasonable returns on investments, and to expansion and growth. 2017, Procopio was dismissed from employment for stealing his co-employee Raul's watch. Procopio filed a complaint for illegal dismissal. The labor arbiter ruled in Procopio's favor on the ground that Raul's testimony was doubtful, and, therefore, the doubt should be resolved in favor of Procopio. On appeal, the NLRC reversed the ruling because Article 4 of the Labor Code, which states that all doubts in the interpretation and implementation of the provisions of the Labor Code, including the implementing rules and regulations, shall be resolved in favor of labor, applied only when the doubt involved the implementation and interpretation of the Labor Code. Hence, the doubt, which involved the application of the rules on evidence, not the Labor Code, could not necessarily be resolved in favor of Procopio. Was the reversal correct? Explain your answer. 3%. In Peniflor versus Outdoor Clothing Manufacturing, GR number 177114, January 21, 2010, the Supreme Court explained the application of Article 4 of the Labor Code regarding doubts on respondents' evidence on the voluntariness of petitioner's resignation. Thus, the High Court said, another basic principle is that expressed in Article 4 of the Labor Code that all doubts in the interpretation and implementation of the Labor Code should be interpreted in favor of the working man. This principle has been extended by jurisprudence to cover doubts in the evidence presented by the employer and the employee. Fujitsu Computer Products Corporation of the Philippines versus Court of Appeals, 494 Philippine Report 697, 2005, as shown above, Peniflor has, at very least, shown serious doubts about the merits of the company's case, particularly in the appreciation of the clinching evidence on which the NLRC and CA decisions were based. In such contest of evidence, the cited Article 4 compels us to rule in Peniflor's favor. Thus, we find that Peniflor was constructively dismissed given the hostile and discriminatory working environment he found himself in, particularly evidenced by the escalating acts of unfairness against him that culminated in the appointment of another HRD manager without any prior notice to him, where no less than the company's chief corporate officer was against him. Peniflor had no alternative but to resign from his employment. Unicorn Safety Glass, Incorporated versus Baarte, 486 Philippine Reports 493, 2004. 2009, Clarito, an employee of One, was dismissed for allegedly stealing One's wristwatch. In the illegal dismissal case instituted by Clarito, the labor arbiter, citing Article 4 of the Labor Code, ruled in favor of Clarito upon finding one's testimony doubtful. On appeal, the NLRC reversed the labor arbiter, holding that Article 4 applies only when the doubt involves implementation and interpretation of the Labor Code provisions. The NLRC explained that the doubt may not necessarily be resolved in favor of labor since this case involves the application of the rules on evidence, not the Labor Code. Is the NLRC correct? Reasons. 3%. The NLRC is not correct. It is well-settled doctrine that if doubts exist between the evidence presented by the employer and the employee, the scale of justice must be tilted in favor of the latter. It is a time-honored rule that in controversies between labor and the employee, doubts necessarily arising from the evidence, or in the implementation of the agreement and writing should be resolved in favor of the labor. Alternative answer. No, the NLRC is not correct. Article 221 of the Labor Code read, in any proceeding before the Commission, the rules of evidence prevailing in courts of law shall not be controlling, and it is the spirit and intention of this code that the Commission and its members and the labor arbiters shall use every and reasonable means to ascertain the facts in each case speedily and objectively without regard to technicalities of law and procedure, all in the interest of due process. The question of doubt is not important in this case. 1998, Article 4 of the Labor Code provides that in case of doubt in the implementation and interpretation of the provisions of the Code and its implementing rules and regulations, the doubt shall be resolved in favor of labor. Article 1702 of the Civil Code also provides that in case of doubt, all labor legislation and all labor contracts shall be construed in favor of the safety and decent living for the laborer. Micomara Company assails the validity of these statutes on the ground that they violate its constitutional right to equal protection of the laws. Is the contention of Micomara Company tenable? Discuss fully. No, the Constitution provides that the state shall afford full protection to labor. Furthermore, the state affirms labor as a primary economic force. It shall protect the rights of workers and promote their welfare. Alternative answer. No, because a law which promotes a constitutional mandate does not violate the Equal Protection Clause. The constitutional mandate is for the state to afford full protection to labor such that, when conflicting interests of labor and capital are to be weighed on the scales of justice, the heavier influence of the latter should be counterbalanced by the sympathy the law should accord the underprivileged. The contention of Micomara Company is not tenable. The constitutional right to equal protection of the laws is not violated by reasonable classification. Thus, it is constitutionally possible to treat workers differently from employers. The social justice principle embodied in the Constitution could be the basis for treating workers more favorably than employers, in the implementation and interpretation of the provisions of the Labor Code and of its implementing rules and regulations. 2006, what is the concept of liberal approach in interpreting the Labor Code and its implementing rules and regulations in favor of labor? 2.5%. The workers' welfare should be the paramount consideration in interpreting the Labor Code and its implementing rules and regulations. This is rooted in the constitutional mandate to afford full protection to labor. Article 4 of the Labor Code provides that all doubts in the implementation and interpretation of the provisions of the Labor Code, including its implementing rules and regulations, shall be resolved in favor of labor. PLDT vs. NLRC, GR number 111933, July 23, 1997. It underscores the policy of social justice to accommodate the interests of the working class on the humane justification that those who have less in life shall have more in law. Paul vs. Santos, GR number 77875, February 4, 1993. 2006, what is the purpose of labor legislation? 2.5%. Labor legislation is an exercise of police power. The purpose of labor legislation is to regulate the relations between employers and employees respecting the terms and conditions of employment, either by providing for certain standards or for a legal framework within which better terms and conditions of work could be negotiated through collective bargaining. It is intended to correct the injustices inherent in employer-employee relationship. 1997, differentiate labor standards law from labor relations law. Are the two mutually exclusive? Labor standards law is that labor law which prescribes terms and conditions of employment like in Book 4, Title 1 and Book 6 of the Labor Code. These books of the Labor Code deal with working conditions, wages, working conditions for women, minors, house helpers and home workers, medical and dental services, occupational health and safety, termination and retirement. On the other hand, labor relations law is that labor law which regulates the relations between employers and workers like Book 5 of the Labor Code which deals with labor organizations, collective bargaining, unfair labor practices and strikes and lockouts. Labor standards laws and labor relations laws are not mutually exclusive, they are complement to each other. Thus, the law on strikes and lockouts, which is an example of labor relations law, includes some provisions on the security of tenure of workers who go on strike or who are locked out. These provisions are examples of labor standards law. 2003. How do the provisions of the law on labor relations interrelate, if at all, with the provisions pertaining to labor standards? Labor relations law focuses its provisions on the collective aspects of employer-employee relationship. Its legal provisions deal with employees organizing unions and how through these unions, employees are able to have collective bargaining with their employer. On the other hand, labor standards law focuses on the terms and conditions of employment of employees as individual employees or those legal provisions dealing with wages, hours of work and other terms and conditions of employment. There may be instances when the provisions of labor relations law may interrelate with provisions of labor standards law. Thus, a CBA which is dealt with in labor relations law may have provisions that improves upon the minimum terms and conditions of employment prescribed in labor standards law, like a CBA providing for a higher minimum wage, or for the computation of a higher overtime pay or the payment of holiday pay not only for regular holidays but also for certain special holidays. 1995. What are the three general classifications of labor statutes? Describe and give an example of each classification. The three general classifications of labor statutes are: 1. Labor relations laws are those labor statutes that deal with the relations of labor and management, like the laws on unions, collective bargaining, unfair labor practices, strikes, lockouts, and picketing. 2. Labor standards are those labor statutes that prescribe standards relating to terms and conditions of employment for compliance by employers, like the laws on hours of work, weekly rest periods, holiday pay, wages, and laws dealing with women, minors, house helpers, and industrial home workers. 3. Social security laws are those labor statutes that provide protection not only to a worker but also to members of his family in case of loss of income or when there is need for medical care brought about by contingencies like sickness, disability, death, and old age. Examples of social security laws are the Social Security Law, Revised Government Service Insurance Act, the Articles of the Labor Code on Employees' Compensation, the State Insurance Fund, and the National Health Insurance Act. 1994. Is there any distinction between labor legislation and social legislation? Explain. Labor legislation is sometimes distinguished from social legislation by the former referring to labor statutes, like labor relations law and labor standards, and the latter to social security laws. Labor legislation focuses on the rights of the worker in the workplace. Social legislation is a broad term and may include not only laws that give social security protection, but also those that help the worker secure housing and basic necessities. The Comprehensive Agrarian Reform Law could also be considered a social legislation. Alternative answer: yes. Labor legislation is limited in scope and deals basically with the rights and duties of employees and employers. Social legislation is more encompassing and includes such subjects as agrarian relations, housing and human settlement, protection of women and children, etc. All labor laws are social legislation, but not all social legislation is labor law. 2006. What property right is conferred upon an employee once there is an employer-employee relationship? Discuss briefly. His employment is not merely a contractual relationship. One's employment is a property right within the mantle of constitutional protection. Colanta versus Carnation Philippines Inc., GR number L70615, October 28, 1986. Hence, the employee enjoys security of tenure and he cannot be dismissed except for cause and only after due process. The worker is thus protected and insulated against any arbitrary deprivation of his job. Philips Semiconductors, Phils, versus Fadriquela, GR number 141717, April 14, 2004. 1996. What are the rights of an employer and an employee? The Constitution in Article 13, Section 3 provides for the following rights of employers and employees. A. Employers' right to a reasonable return on investments, and to expansion and growth. B. Employees' right to a just share in the fruits of production, self-organization, collective bargaining and negotiations, and peaceful concerted activities, including the right to strike in accordance with law, security of tenure, humane conditions of work, and a living wage. And participate in policy and decision-making processes affecting their rights and benefits as may be provided by law. 2000, Professor Juan de la Cruz, an author of the textbook Commentaries on the Labor Code of the Philippines, citing an American case, wrote, "It is said that the prohibition against the issuance of a writ of injunction in labor cases creates substantive and not purely procedural law." Is there any statutory basis for the statement or comment under Philippine law? 5%. Yes. The statutory basis is Article 254 of the Labor Code. It prohibits issuance of injunction, as a matter of policy, to resolve disputes except as otherwise provided in Articles 218 and 264 of the Labor Code. Caltex Filipino Managers and Supervisors Association vs. CCR, 44 SCRA 350, 1972. 2003, may social justice as a guiding principle in labor law be so used by the courts in sympathy with the working man if it collides with the Equal Protection Clause of the Constitution? Explain. Yes. The state is bound under the Constitution to afford full protection to labor, and when conflicting interests collide and they are to be weighed on the scales of social justice, the law should accord more sympathy and compassion to the less privileged working man. Fuentes vs. NLRC, 266 SCRA 24, 1997. However, it should be borne in mind that social justice ceases to be an effective instrument for the equalization of the social and economic forces by the state when it is used to shield wrongdoing. Corazon Jamer vs. NLRC, 278 SCRA 632.